On Law Weekly today, we talk issues of lawful and unlawful assembly/protest, appointment of public office holders, and justice reform. We talk with the Senior Advocate of Nigeria, Ifedayo Adedipe. Also showing on the program today, two senior lawyers share their views on the propriety of nominating to office persons under investigation for allegations of corruption, plus our recap of the top trending stories from the courtrooms. Hello and welcome to the program. I am Shola Shoyeli. The week began on an interesting note with the hashtag #RevolutionNow protest. Following the protest, which held in some parts of the country, several persons were hauled before different courts on charges of unlawful assembly and breach of peace. The court has also ordered the detention of one of the conveners of the protest, Omoyele Sowore. But is there any propriety for labeling the protest as an unlawful assembly? This was where I began my interview with Senior Advocate of Nigeria, Ifedayo Adedipe.
The right to assemble peacefully and make demands of government is part and parcel of democratic governance. Now, protests can be peaceful and violent. The violent ones are protests in which people throw missiles, damage properties, injure people. Those ones are not permissible under any guise. Now, when you talk about, is it revolution? Revolution is not something you mouth. I mean, it's not something that you organize in the public glare with drums, singing, dancing. I would put that one as part of youthful exuberance on the part of whoever might be organizing it. But the one that the law frowns against is a protest in which the rights of other citizens are not respected by the protesters. That is not permissible. That cannot be allowed in any society, be it democratic or authoritarian. But the issue of revolution now, I mean, until we heard that the DSS arrested Mr. Sowore and took him into their custody, I didn't even hear much about it. So I think it is a government apparatus that are making a mountain out of a molehill. If somebody wanted to organize a revolution, I don't think he will advertise it. I don't think he will give notice. It's like when people organize military coups. Did they tell people, we are coming tomorrow to come and remove government? I think it is part of the misconception and the need to let the government of the day know they are working and probably send a signal, a very dangerous signal, that this government will not tolerate dissenting voices. Otherwise, to say we will organize revolution now is nothing. Let him go and try it first. Then you arrest him, but not before, in my humble opinion.
We've seen a court order for the remand of Mr. Sowore for 45 days. Justice Taiwo is reported to have said that although the hearing of the application was ex parte, but as provided by Section 27(1) of the Terrorism Prevention Amendment Act, the use of the word may in the provision is directory and not discretionary. Please, can you explain this law for us and the ruling behind it?
Well, first of all, we take it from the point of view of what the Constitution provides. The Constitution permits the making of a law that is permissible in a democratic setting. Otherwise, you can't pick a man and just lock him up for 45 days. But there's a validly enacted law of the National Assembly, Terrorism Prevention Act, that made provision for the detention for a certain period to enable security agencies to carry out thorough investigation. And I think that is why that law is put in place. Now, if you pick up a man and in 45 days of diligent investigation, you are not able to establish a case against him, then in my humble opinion, you just release him. I believe the learned trial judge was well in order when he said, look, take 45 days, let us see what you have. If you think you needed more time, you come back. But I believe that at that point in time, the detainee should be entitled to the services of his lawyer to challenge the appropriateness of further keeping him for another 45 days. The powers of the state security agencies, police, army, military intelligence, etc., are so awesome. They can do and undo. So if in 45 days they are not able to get information that could nail an individual, then it will seem that they will be fishing for information, and that will not be right. So I think in the context of the provisions of our Constitution and the fact that that law was validly made by the National Assembly. Remember, the National Assembly is the representative of the people. Even their wisdom, they think that, yes, we could have situation in which the security agencies will need time. You know, there are no magicians, mark you. They will need to investigate, collate data, consult, and so on. Maybe 3, 4, 5 days might not be enough. So you need probably 2, 3 months. I think that is the basis for that legislation. But after that, I think the detainee, or whoever it is that has been hauled in, should be entitled to services of a lawyer. So the judge, in my humble opinion, was well right in the way he made the order.
So if after 45 days you're not able to prove anything against the individual, does he get any compensation, or it just dies?
Some areas of our laws need to be tested. For instance, people who are routinely hauled before a court of law, they spend 5, 6, 7 years. At the end of the day, nothing against them, and they go empty-handed. Meanwhile, that period of their life is forfeited for nothing. I think the time has come for people to be challenging such needless erosion of their liberties and rights. So, if after 45 days they have nothing against him, and it's mere fishing or just an attempt at repression, he might as well challenge it and test it in our law courts. And I hope the courts will stand up to defend the rights of our citizens. What has really worried me in recent times is that wrongdoing on the part of the government is becoming more manifest. And nothing challenges the legitimacy of government than wrongdoing on the part of government itself. If courts make orders and government that is elected chooses to disobey that law and brings in some awkward explanation that you see the public interest overrides this.
Or national security.
National security, whatever the argument. I believe that is an overkill. It does not lie in the mouth of the government that went join issue with a man in a court of law and is defeated to say, well, we will not obey this. That is wrongdoing on the part of government. It is wrong. It should not be allowed.
I want to switch to another matter of public interest. That's talking about the ministerial screening that we saw. We've been told that the ministers will be sworn in on August 21st, following their successful screening and confirmation. But I want to look at the screening process. There are those who have issues with it, and we've seen criticisms trailing the bow and go, that some people say it's even maybe been taken overboard when you extend it to state legislatures and all of that. But what do you think?
Thank God for cable television. We've seen how these things are done elsewhere. We abuse things in this country, you know. The legislature is supposed to perform oversight function over the executive, because, mark you, the executive has all the power to abuse it, you know, the responsibilities cast on it by law. It is the function of the legislature to ensure that this does not happen. In recent years, we've had ridiculous legislature in this country, and the current National Assembly does not exert shears at all. Prior to now, the argument out there is that the incoming National Executive will be a rubber stamp, and some people said, no, allow them, they are cooperating. The National Assembly did not screen any ministerial nominee. What we saw was they came, showed their faces, and left. There were no screenings for two major reasons. You just don't screen a man when you don't even know the job you want him to perform. And I believe this idea of submitting names and asking legislators who may not even know better to ask random questions. I recall one was asking Festus Keyamo to sing the second stanza of the national anthem. What does that got to do with his competence to be a minister? I believe that we need to ask ourselves whether we're really serious. I mean, it starts with the executive that is sending a name without attaching portfolio. That should not happen. You should attach portfolio, and then committees will screen these people for the respective portfolios. somebody is going to be the Attorney General of the Federation. You want to know from him what will be the attitude of your office as Attorney General to disobedience to court order, to the invasion of judges' homes, as we have seen under this administration. These are the questions you will ask a prospective nominee for the office of Attorney General. You don't want an Attorney General who will tell you we can choose to disobey.
Where do you stand on the arguments made by some persons, including Senator Dino Melaye, that people with criminal cases pending against them and the propriety of their being nominated for public offices? I know that the law does not say anything, but should the law say something about such situations?
Let us start from the basics. When anyone is accused of any crime in this country, under our constitutional democracy, the Constitution presumes him innocent. I will not join the crowd of people saying because somebody has been accused, is therefore disentitled to be given important position. You go ahead and try him. If you find him guilty, then let us see how the government will retain him. But I do not join the crowd to say that because some people have been accused, therefore they cannot be nominated. Mark you, in this country, people can accuse people of anything, just about anything. So you need to investigate carefully before you adjudge anybody guilty of an offense. So I do not subscribe to the view that because people have been accused serially, therefore they cannot be used.
But the argument that if people are accused of an offense, and then you nominate them for public office, and that is talking about any ministerial, any public office, board appointments and all of that, that then you then give them an opportunity to amass wealth and build a war chest, which they can then use to stall proceedings, as we've seen happened in this country. Don't you think there's some merit in that argument?
No, there's no merit in that. Utterly unmeritorious. First of all, ministers are not supposed to go and amass wealth as people make it. It's in this country I hear of ministers belonging or having juicy appointment. Until you find a man guilty, it is wrong to presume him guilty. Now, if somebody is in a ministry, is entitled to defend himself, I do not think the amount of money is what will free a man. They may take good lawyers, they may stretch the system, but the facts remain the facts. And we must perish the idea that people should be presumed guilty in this country. I know that the president, with profound respect to him, is of that cast of mind that if you accuse somebody, well, lock him up. Let him come and prove his innocence. But that is at variance with the provisions of our Constitution.
Let's come back home to the judiciary.
Yes.
Ahead of the new legal year, and as part of an agenda setting, what can our new CJN, well, it's not so new, but what can the CJN do to make justice delivery faster?
The reformation I will see will be, first of all, we need to go digital. We need to be modern. I think it is high time we ditch the idea of analog adjudication, a situation in which judges write in long hands, still how many long hours, taking notes. Although we now do front loading and the rest of them, but we need to still go further. Secondly, I think we lawyers need to ask ourselves hard questions. I think it's a regulated profession. We have rules of professional conduct for lawyers. Some of the things I see, I just shudder. It is not how loudly you protest your innocence or so on pages of newspaper, on television, that will determine your innocence. It is the facts presented before the judge who is hearing the case. And so we lawyers need to call ourselves to order. Thirdly, people should know that it is not public sentiment that determines whether you win a matter or not. It is the facts as well as the law on the facts that you present before the court of law.